The morning I discovered what my parents had done, I was standing in the break room at work, eating a granola bar over the sink, when my phone buzzed with a text from a number I didn't recognize. Hey, are you related to the Hargrove family on County Road 9? The farm with the white fence and the old grain silo? Just want to make sure we have the right contacts before the crew comes out Monday. I stared at that message for a long time. Long enough for my coffee to go cold. My grandfather, Earl Hargrove, had died 11 months earlier. Quietly. In the farmhouse he'd built with 2 other men and his own hands in 1967. He was 79. He had a vegetable garden that ran the full length of the south fence, a dog named Biscuit who outlived him by 4 months, and a manila envelope he had pressed into my hands at Thanksgiving 2 years before he passed. Keep this somewhere safe, he'd said. Not in this house. Somewhere your mother can't find it. At the time, I thought he meant it as a joke. My mother, Patricia Hargrove, had a habit of throwing things away, old photos, letters, anything that took up space and reminded her of obligations she'd rather forget. I figured Grandpa Earl was just being careful with some old insurance policy or a stock certificate. I put the envelope in the fireproof lockbox in my apartment closet and forgot about it. Until that text. I wrote back, "Yes. What crew? What's happening Monday?" The reply came in 2 minutes. "Oh, I'm with Hartwell Land Partners. Your parents signed the purchase agreement last month. We're scheduled to start the survey and preliminary grading on the back 41st. Figured someone from the family might want to be there." I read that 3 times. Then I set my coffee cup down very carefully, because I could feel my hands wanting to shake, and I didn't let them. My parents had sold my grandfather's farm. The farm he'd worked for 52 years. The farm where I learned to drive a tractor at age 10 and where, every August, Grandpa Earl and I would sit on the porch after dinner and count the bats coming out of the old barn at dusk. He called it the evening show. He never missed it. My parents had sold it. And nobody had called me. I drove straight from work to my apartment, pulled the lockbox from the closet, and opened the envelope. Inside was a folded document, handwritten on the top page in my grandfather's careful, deliberate cursive. The kind of handwriting that belongs to a man who learned penmanship as a discipline, not a decoration. Below it were several typed pages, signed and notarized. It was his will. I sat on the floor of my closet and read it twice. He had left the farm to me. The full parcel legal description, parcel number, metes and bounds. He had named me as executor, and at the bottom, in a separate handwritten addendum, dated 14 months before his death and signed in front of 2 witnesses, he had written something that felt less like a legal clause and more like a warning he knew I'd eventually need. If Patricia Hargrove or Gerald Hargrove attempt to sell, transfer, encumber, or contract this property in any manner, they are immediately and permanently disinherited, and the full title shall vest in my granddaughter, Claire Hargrove, with instructions to record notice and seek injunctive relief without delay. Grandpa Earl had known exactly what they would try. He had built a trap for it, 26 months before it happened. I called my cousin Danny, who was a paralegal in Clarksburg, and read him the whole thing over the phone. He was quiet for a long moment. Then he said, "Claire, that addendum is a codicil. It's legally binding if it was properly witnessed. But the problem is, if your parents already recorded a transfer, they may have claimed he died without a will. They would have had to swear to that." I said. "Yes," Danny said. "Under oath. On a notarized affidavit." I already knew, before I walked into the Calhoun County Recorder's office the next morning, that what I was going to find there was going to be worse than I'd imagined. That's the thing about discovering a betrayal slowly. In pieces, each piece is colder than the last. The recorder's office in our county is a single-story brick building that smells like carpet cleaner and old paper. There are 2 American flags flanking the door, and a laminated sign above the front counter that reads, "All recorded documents are public record." I took a breath and walked up to the counter. The clerk's name tag read Denise Owens. She had reading glasses on a beaded chain, and the expression of someone who has been asked every possible question about property records and has stopped being surprised by any of them. "Hi," I said. "I need the deed history on a parcel, the Hargrove farm on County Road 9, and any probate filings under the name Earl Hargrove." She typed. The keyboard clicks sounded very loud in the quiet room. Then she stopped. Not the normal pause of someone still searching. The kind of pause where a person finds something unexpected and takes a moment before they respond to it. "What's your name?" she asked. "Claire Hargrove. I'm his granddaughter." She nodded once. "Give me just a moment." She stood and walked to a back office. When she came back, she was carrying a thin folder and a printed sheet, and she set them on the counter with the careful deliberateness of someone handling evidence. "The parcel shows a recorded transfer," she said. "Filed 6 weeks ago." "To Hartwell Land Partners?" I asked. "Yes." "And the grantor?" She turned the sheet toward me. The line read, "Estate of Earl Hargrove, Was there a probate case opened? I asked. Denise clicked again. Frowned. Clicked again. No active probate case under Earl Hargrove in this county, she said slowly. So, how did the estate transfer the property? She pulled the attachment from the recorded instrument and opened it on her screen. Affidavit of heirship, she said. Her voice had gone very flat, the way voices go when people are reading something they wish they weren't reading. What does it say? It claims the decedent died intestate. No will. And it names Gerald and Patricia Hargrove as the sole heirs with authority to convey. My throat tightened. Not with grief. With precision. Is there a deposited will on file? I asked. My grandfather gave me a copy of his will. But he may have also deposited one here for safekeeping. Denise looked at me for a moment, the assessing look of someone deciding whether you're asking a procedural question or a dangerous one. Then she turned back to her screen and navigated to a different system. She stopped. Her expression changed the way expressions change when a person finds the exact thing they were afraid to find. There is a deposited will packet, she said quietly. Filed years ago, under Earl Hargrove. A pause. It was accessed last month. By whom? I asked. She navigated to an access log. Her eyes moved across the screen. Then she turned the monitor slightly toward me. The log showed a public terminal access. Timestamped at 9:14 a.m. on a Tuesday morning, 4 days before the affidavit of heirship was recorded. The access was logged under the name Patricia Hargrove. My mother had come to this building. She had pulled up my grandfather's will. She had read it. She had paid the copy fee 47 days before she signed a sworn affidavit claiming that no will existed. I kept my voice level. I need certified copies of the deed history, the recorded transfer instrument, the affidavit of heirship, and the access log showing that Patricia Hargrove viewed the deposited will packet. Denise was already printing. 20 minutes later, I was sitting in my car in the parking lot with a stack of certified documents in my lap, calling the only attorney I trusted completely. Marcus Webb is a real property and probate attorney who went to school with my uncle and has never once wasted a sentence. He answered on the second ring. Marcus, I said. My parents recorded a fraudulent affidavit of heirship and transferred my grandfather's farm to a developer 6 weeks ago. There's a deposited will that names me as devisee and executor, and the county access log shows my mother pulled up the deposited will 4 days before she swore under oath that no will existed. 3 seconds of silence. The kind that means a lawyer is already building a motion. Okay, he said. First thing, where's the will now? I have the original. My grandfather gave it to me 2 years before he died. I also have a certified copy from the county's deposited packet. Good. We're filing for probate today. Emergency petition. And we're recording a notice of pending action against the parcel immediately that clouds the title and puts the developer on notice that no clean closing is possible. They're sending a survey crew Monday, I said. Then we're also filing for a temporary restraining order today. I need the certified will, the deed instruments, and the access log in my inbox in the next 30 minutes. I was already driving back to the copier in the recorder's lobby. You'll have them in 20. By 4 o'clock that afternoon, Marcus had filed the probate petition, the emergency motion, and the notice of pending action. The county recorder stamped the notice and assigned it an instrument number. The parcel's public record, which anyone can look up from any computer now, showed a single word that every title company in the state treats as a stop sign. Disputed. I called the number from the Hartwell Land Partners text. A man answered. Hartwell Land. This is Brian. Hi, Brian, I said. My name is Claire Hargrove. The farm parcel your company believes it purchased was transferred to you based on a fraudulent affidavit of heirship. The actual will was located and filed for probate today. A notice of pending action was recorded this afternoon. You don't have clean title. Silence. Then, hold on. Let me get our legal team. A woman came on the line 30 seconds later. Measured voice. Legal training in every syllable. Miss Hargrove. This is Renee Falk. Counsel for Hartwell. Your parents represented that they had full authority as heirs. They represented falsely, I said. They accessed the deposited will 4 days before signing an affidavit claiming it didn't exist. The county has the log. Longer silence this time. We'll need to verify this with the recorder's office, Renee said carefully. That's public record, I replied. You can pull it right now. A pause. Then her tone shifted, not warmer, but more careful. The shift of someone who is mentally separating herself from a transaction she no longer wants to be attached to. We will not proceed with any entry or site work pending review, she said. Put that in writing, I said. Her email arrived in 11 minutes. My parents didn't find out that I'd filed until the next morning, when Marcus served them with the probate petition and the restraining order. My father called me at 7:15 a.m. I let it go to voicemail. He left a message that lasted 4 minutes and 20 seconds, during which he called me ungrateful twice. said I was weaponizing paperwork against my own family, and ended with, "Your grandfather would be ashamed of you." I saved a voicemail. Evidence has timestamps. My mother texted, "We did what was best for everyone. The farm was just sitting there. You live in an apartment. What were you going to do with it?" I didn't respond. I was already in Marcus's office reviewing the probate hearing schedule. What I noticed, and what I want you to notice, because this is the part that most people miss, is that my parents never actually claimed the will didn't exist because they didn't know about it. They claimed it didn't exist because they knew exactly where it was, knew it blocked everything they were planning, and decided to outrun it. My mother had driven to that recorder's office on a Tuesday morning. She had logged in at the public terminal. She had pulled up the deposited packet. She had read the will that left the farm to me. She had read the codicil that specifically named her and my father as the people who couldn't touch it. She had paid the copy fee of $47 paper trail that would follow her for the rest of the legal proceedings. And then she had gone home and helped my father sign a sworn, notarized affidavit claiming my grandfather had died without a will. The probate hearing was 3 weeks later. The will was admitted without contest. There was no credible challenge to it. I was formally appointed executor. The judge reviewed the affidavit of heirship alongside the access log and the copy receipt, and he read both documents aloud in open court in the way judges do when they want the record to be very clear about what they are looking at. Then he referred the affidavit, and all associated records, to the district attorney. The fraudulent conveyance was unwound through a quiet title action. Hartwell Land Partners, once they understood that my parents had sold them a property they never legally controlled, withdrew from the transaction and filed a civil suit for restitution. Their attorney preserved every communication my parents had made during the sale. Those communications became part of the criminal case. The DA filed charges, filing a false instrument, perjury related to sworn statements, and attempted fraud against a purchaser. My parents were arraigned on a Thursday morning. They posted bond. They were issued no-contact orders that prohibited them from having any involvement with the farm while the case was pending. My father served time. My mother accepted a plea agreement that included restitution, probation, and a permanent restriction from representing authority over any estate property. Anyone's estate. Not just mine. I placed the farm in a protective trust that makes it legally impossible for it to be sold without court approval and multiple independent trustee signatures. The kind of structure my grandfather might have set up himself, if he'd trusted anyone enough to do it for him. The farm is still there. The grain silo. The white fence. The vegetable garden along the south fence, which I replanted in the spring because the beds were overgrown but the soil was still good. I go out there on Sunday mornings. Usually. I make coffee in the farmhouse kitchen and drink it on the porch where Grandpa Earl used to sit. The bats still come out of the old barn at dusk. I count them the way he taught me. A habit I apparently can't quit. The land is quiet. Legally, officially, undeniably mine. Here's what I want you to take from this. Because I know some of you are watching this and thinking about your own family and your own inheritance and the things people you love might do when money gets involved. My grandfather didn't protect that farm by hoping for the best. He didn't protect it with a conversation or a handshake or trust. He protected it with paper-specific, dated, witnessed, filed, and certified paper. He protected it by thinking 10 steps ahead of people who would only start planning the day he died. And when his plan was tested, it worked. Not because the law is perfect. Not because every clerk is as careful as Denise Owens or every deputy as fair as the one who showed up that morning with the restraining order in his hand. But because the record existed. Because the timestamps existed. Because the $47 copy receipt existed. The truth doesn't always win because it's true. It wins because someone wrote it down. In the comments, I want to hear from you. Has your family ever had a property dispute? Or do you know someone who has? And if you found out a family member was trying to sell something that was meant for you, would your first call be to a lawyer, or would you confront them first? If this story resonated with you, subscribe. There are more of these. And they are all real. And they are all things that happen to ordinary families every single day.